Thank you for joining us for Manitoba's Access to Justice Week event. My name is Natasha Brown, and I'm the Access to Justice Coordinator here at the Law Society of Manitoba. Between 1871 and 1875, treaty commissioners acting on behalf of the Crown signed treaties 1 through 5 with First Nations leaders. The treaties included agreements with respect to the use of land we call Manitoba. This land has been the traditional territory of the Cree, Dakota, Dene, Oji-Cree, and Ojibwe nations for millennia before the signing of the treaties. We would like to acknowledge that today's webinar hosts are situated on Treaty 1 territory, the traditional lands of the Anishinaabe, Cree, and Dakota peoples, and the homeland of the Métis Nation. We're pleased to welcome both presenters and participants from locations in different treaty territories across Canada. We acknowledge with respect and gratitude the many First Nations, Inuit, and Métis peoples whose footsteps have marked this land for centuries. As many of you may have noticed, all webinar viewers will have their microphones muted and their cameras off for the duration of this event. Participants are able to pose any questions they have into the Q&A boxes you'll see below, and we hope to leave time towards the end of this event to answer your questions. Please don't enter questions into the chat function. Use the chat only for technical assistance. So please use the Q&A for any questions you may have. You'll also notice that this session is being recorded. And following this event, we will make this recording widely accessible and free of charge to both registrants and non-registrants to view at their convenience. We are so very fortunate to welcome such renowned speakers to our panel discussion, Access to Justice, Indigenous Perspectives. This is the first time Manitoba has hosted an event on its own with respect to the National Access to Justice Week. I wish I could fulsomely share the extensive biographies of each of these individuals, but for sake of time, I will only highlight a portion of their most significant achievements. Joining us today are the following people, starting with the Honourable Murray Sinclair. The Honourable Mr. Sinclair is Anishinaabe and a member of the Peguis First Nation. He is a 4th degree chief of the Medewan Society, a traditional healing and spiritual society of the Anishinaabe Nation, responsible for protecting teaching, ceremonies, laws, and the history of the Anishinaabe. He graduated from law school in 1979 and has been involved with the justice system in Manitoba for over 40 years as a lawyer representing Indigenous clients, as an adjunct professor of the law school, Robson Hall, University of Manitoba, and as an associate chief judge of Manitoba's provincial court, and as a justice of the Manitoba Court of Queen's Bench. He was the first Indigenous judge appointed in Manitoba and Canada's second. He served as co-chair of the Aboriginal Justice Inquiry of Manitoba and as the Chief Commissioner of Canada's Indian Residential Schools Truth and Reconciliation Commission. He retired from the bench and was appointed to Senate in 2016. After retiring from the Senate in early 2021, he returned to the practice of law and is now mentoring young lawyers at Cochrane Saxford LLP. Our second panelist is Dr. Cindy Blackstock. She's a member of the Gitxsan First Nation and the Executive Director of the First Nations Child and Family Caring Society, and a professor at McGill School of Social Work. She has over 30 years of experience working in child welfare and Indigenous children's rights, and has published more than 75 articles on topics relating to reconciliation, Indigenous theory, First Nation child welfare, and human rights. Dr. Blackstock was honored to work with First Nations colleagues on a successful human rights challenge to Canada's inequitable provision of child and family services and failure to implement Jordan's Principle. This hard-fought litigation has resulted in hundreds of thousands of services being provided to First Nations children, youth, and their families. Dr. Blackstock recently served on the Pan American Health Commission on Health Equity and Inequity, and fundamentally believes that culturally based equity is fundamental in meaningful reconciliation. Our third panelist is Dr. Pamela Palmater. She is a Mi'kmaq citizen and a member of the Eel River Bar First Nation in northern New Brunswick. She has been a practicing lawyer for 16 years and is currently an associate professor and chair in Indigenous governance at Ryerson University. She has 4 university degrees, including a BA from St. Thomas in Native Studies and an LLB from the University of New Brunswick, where she won the Faskin Campbell Godfrey Prize in Natural Resources and Environmental Law. She went on to complete her master's and doctorate in law from Dalhousie Law School, specializing in First Nations law. Dr. Palmater has been studying, volunteering, and working in First Nations issues for over 25 years on a wide range of social, political, and legal issues like poverty, housing, child and family services, treaty rights, education, and legislation impacting First Nations. She came in second in the Assembly of First Nations election for National Chief in 2012 and was one of the spokespeople, organizers, and public educators for the Idle No More movement in 2012-13. She has been recognized with many awards and honors. Some of these include the 2012 YMCA's Women of Distinction Award in Social Justice, the 2012 Women's Courage Award in Social Justice, Canada's Top Visionary Women Leaders 2014, and most recently the 2015 UNB Alumni Award of Distinction. She has published numerous articles and her book including her book Beyond Blood, Rethinking Indigenous Identity, and her political blog, Indigenous Nationhood, has been reposted and reprinted in numerous formats and will soon become a book. Finally, our last panelist is Brad Regehr. Mr. Regehr is a member of the Peter Ballantine Cree Nation in Saskatchewan and survivor of the 60s Scoop. He joined Maurice Law in 2017 as a partner in the Winnipeg office. Over his 20 years of practice, he has worked on a variety of legal matters, including Aboriginal law. He continues to provide advice to a wide range of clients, including First Nation and corporate clients. He's appeared in the Manitoba Court of Queen's Bench, Manitoba Court of Appeal, as well as the Federal Court of Canada and the Federal Court of Appeal. Mr. Regehr was part of a legal team that successfully defended a challenge to First Nations tax laws, and he has also acted for the First Nation with respect to a major hydroelectric project. He has and continues to advise First Nations on land claim matters, and it was involved in litigation concerning the disposal of the Capion Barracks in Winnipeg. Mr. Regehr recently completed a 1-year term as president of the Canadian Bar Association, the first Indigenous lawyer to hold that office. During his tenure as president, he made truth and reconciliation calls to action his personal priority. The CBA's continuing professional development program, The Path, which focuses on the history of Indigenous and Crown history, has become the most successful CBA program in its history. In addition, the CBA launched its Truth and Reconciliation Toolkit for law firms during Mr. Regehr's pregnancy. Now turning to today's moderator, Danielle Morrison. Ms. Morrison is a proud Treaty 3 member of the Anishinaabe, Neogashing, let me rephrase that. She's a proud Treaty 3 member of the Anishinaabe of Neogashing. She practices in the areas of Indigenous law, child protection, and litigation, and received her call in July 2020. Prior to law school, Ms. Morrison developed a career in program delivery, policy review, and advocacy with respect to Indigenous-led movements and nonprofit organizations at both the grassroots and national levels, including the National Association of Friendship Centers and the Assembly of First Nations. While in law school, Ms. Morrison held an executive position with the Manitoba Indigenous Law Students Association and co-chaired the Manitoba Law Students Association's Community Outreach Committee. In 2016, Ms. Morrison was the lead community and cultural engagement coordinator for the national tour of the Royal Winnipeg Ballet's Going Home Star, Truth and Reconciliation, and has since co-founded the Indigenous Advisory Committee for the Royal Winnipeg Ballet. Ms. Morrison is currently an associate with the Honourable Ms. Senator Sinclair's firm, Cochrane Saxberg LLP. And now I'll turn things over to you, Danielle, to lead today's discussion.
Thank you very much, Natasha. And maybe at this point, we'll get all of our amazing panelists to turn on their cameras as well, so we can see all of their good-looking faces. Thank you all for joining us today. I just want to open by acknowledging the incredible work done by each of you in blazing the trail for new Indigenous lawyers and advocates such as myself, and how humbled I am to be able to moderate this important discussion. And judging by the maxed out number of participants on the call today, it's apparent that we're at a juncture in history where Canada and the world are listening and they're paying attention. And it's leaders such as yourselves that we're so lucky to turn to for your expertise and your experiences. So with that, I wanted to start with a question to the group, and we'll start with the Honourable Murray Sinclair about what are the most prevalent issues from an Indigenous perspective for access to justice today?
Well, thank you, Danielle, and greetings to everybody. Thank you for the invitation to the organizers of the Law Society for inviting me to be part of this very important panel, and an important topic it is. You're quite right to point that out. The issues that I think we're going to have to talk about, and we talk about the issues of access to justice, not only have to do with getting access to legal counsel, access to the courts, and being able to argue certain principles of law that have to this point in time been ignored by the courts. But it's also, I think, for me now, I think one of the most important questions about access to justice is about the issue of relating to the sovereignty of Indigenous peoples, and the fact that going as far back as the Royal Proclamation of 1763, the British Crown acknowledged that Indigenous people's sovereignty was to continue to exist even after a relationship had been entered into with the Crown, and that the Crown's claim to certain rights because of the doctrine of discovery was still subject to Indigenous sovereignty. That Royal Proclamation of 1763 contained that recognition, which is not to say that it's a source of traditional law or source of Indigenous law or the source of Indigenous legal thinking. That comes from the people themselves. And many of the legal practitioners out there are somewhat surprised, and it always surprises me that they're surprised by the suggestion that Indigenous people had laws, or that they had governing principles that were equivalent to laws. But if you think about just any community of people that have existed for as long as Indigenous people have existed in this part of the world, and we're talking in the area of at least 25,000 years, if not longer, in some parts of the country, you cannot exist as a community of people, as a tribe of people, without there being some internal governance that has to be in place. And that internal governance not only has to do with the way that people within the community function, but also how insiders are allowed to relate to that internal functioning, and how outsiders relate to the overall community of people. And so that's a question of what is the nature of those traditional legal principles. How are they manifested today? How can they be manifested today? What happened to them in the meantime? And whether or not they continue to exist, or are they covered by the principles that are being recognized in Section 35 of our Constitution, I think are all very important principles. And I think we're going to see more and more litigation around that. And legal practitioners in particular need to start getting their heads around the idea that Indigenous people are no longer going to be happy with merely arguing their claims in accordance with existing Canadian law. They're going to want to argue their claims, or argue their positions or their existences within the context of their own legal traditions. And so when we talk about access to justice, we shouldn't just keep it to the narrow focus of access to court, access to lawyers, access to rights protected by the courts. We need to think outside of the box. We need to think about the fact that the Canadian court system cannot be and should not be seen as the court of last resort or only resort when it comes to Indigenous peoples and Indigenous laws. I'm always caught by the fact that people talk about, and we've heard it a number of times from our current Prime Minister, where in situations of conflict, particularly in the West Coast, he has said that the protesters who are protesting against Indigenous rights, Indigenous lands being negatively affected by development, and court injunctions have been issued. There has always been, to me, a couple of questions that's arisen. One is that what effort has the court made, or what effort has been demanded of the applicants by the court to explain how Indigenous sovereignty was ever lost in British Columbia, and why, in fact, the rights of a capitalist corporation can override the Indigenous and internal sovereignty of Indigenous people. And I've never seen, looking at all of the injunctions over the years, I've never seen a situation where the courts have ever held that standard up against the standard that has been claimed by individuals acting on behalf of capitalist corporations. And I think it's about time that courts themselves begin to raise those questions, rather than simply saying, well, Indigenous people are not here to argue the other side, therefore we have no choice. The reality is that the court itself has got to be familiar enough with the legal principles to be able to raise that on its own. Secondly, I'm always stunned at the statements by people like our Prime Minister, who has said repeatedly, and not just this Prime Minister, but other Prime Ministers have said, we are a nation of laws, and therefore law must be respected. When in reality, it's the very fact that Indigenous laws were never respected that is often at the heart of the conflict. And the lack of respect for Indigenous law is usually an issue that is not recognized. And that means that when the statement is made, we are a nation of laws, the response could be and should be, well, what about the laws and the legal rights of Indigenous people? Because they have rights too, and certain laws too, that Canadian governments have never respected and continue to not respect, even in this day of reconciliation. So that will be my initial offering to this conversation, because to me, the overriding question right now is, where are we going to go when we start to talk about access to justice? And that's where I see the big issue being in front of us. Thank you.
Only which, and that truer words have never been spoken. Indigenous laws were never respected. And I feel like that's such a quotable and maybe a theme that we can really turn to throughout the panel, especially when we're talking about the indigenization of our legal system and what the limitations of that are, because it only goes so far, as you pointed out, in terms of what we can do within the Western legal system and what we should be doing with our Indigenous legal practices. So I want to turn to Dr. Cindy Blackstock and ask her the same questions about what are the most prevalent issues from your perspective on access to justice.
I agree, of course, no surprise with Murray's terrific intervention. I'm not a lawyer, as you know, Danielle. And so I entered into this scheme thinking, This is going to be a piece of cake. All we have to do is show the government how they're treating this generation of children unequally. We're going to work with First Nations experts all over the country who know a lot more about this stuff than I do. We're going to present a solution, and they're going to remedy these inequalities that were driving kids into care at greater numbers than in residential schools. That kind of naivete had a presumption that the federal government actually believed the preamble of the Bill of Rights, where it talks about morality and spirituality, and where it talks about observance of the law as fundamental to freedom. And I also was naive enough to believe the brochure. This tells you how long this case has been on. I'm using the word brochure by the Canadian Human Rights Commission, that filing a human rights case is meant for people just like me, who are just grassroots folks who want to see justice done. Okay. You know, this is the 7th anniversary today of the conclusion of the final arguments of this case. It was 7 years ago that we were finally concluding the final arguments. And of course, it's been 5 years since the tribunal ruled. We've had 20 non-compliance and procedural orders in this case since 2016. And this is after the Truth and Reconciliation Commission listed child welfare as the #1 call to action and Jordan's principles #3. So there's been an ongoing series of access to justice issues that I just want to preface here, and then maybe we can pick on those themes later. The first is the real lack of ability of being able to hold the federal government, a lawmaker in this case, accountable for its own breaches of its own laws. The level of resources that are necessary to deal with the Department of Justice is just so overwhelming that I think it beguiles a lot of human rights cases coming forward that ought to come forward. From the very outset, we have this overwhelming fear that if you file a human rights case against Canada, that there's going to be some retaliation, be that cutting in funding or your community members aren't going to be getting the help they need. That's a legitimate fear. And it happened in our case. We got all of our funding cut by the feds within 30 days of filing it. So that kind of breach of human rights defenders' ability to bring cases forward is a legitimate issue, and it ought to be remedied by Canada enshrining the UN Declaration on Human Rights Defenders into domestic law with enforcement. The second is, of course, once you file it, then you have to deal with the Department of Justice, which is going to throw every procedural mechanism at you that you never even knew existed. That is another area where I think there's a break, or at least was for me. I assumed they would argue it on the merits. And so I had all the evidence piled up, and I was so naive, I did not realize that they'd be going after jurisdiction. They're still going after jurisdiction because the facts are against them. So being able to kind of understand what those arguments are likely going to be as a new litigant coming into the field would be very helpful. And then having actual expert legal advice, even as you're framing your human rights complaint. I wrote our human rights complaint, and I don't know, someone was looking out for me because thank God I put a couple words in there about Section 5 of the Canadian Human Rights Act, because otherwise this very important case would have been kicked out because I didn't know the law well enough. The other thing is that Canada, I shouldn't have been surprised, but it goes to Murray's point. Canada is prepared to break the law and break conventions of court rules when there are no consequences for them, or when those consequences are less than the benefits. We saw that with disclosure being regularly weaponized, in my view, by the Department of Justice, not only in our case, but in cases against residential school survivors, et cetera. So being able to kind of pick out these patterns in what the Department of Justice is throwing at you would help future litigants going forward. The final thing I'd say is regarding children's participation in litigation. Children have a right to participate in cases that affect them. And in this case, we had First Nations children coming and young people wanting to be a part of the case, but also all other children, because they did not see this as being fair, what the government was doing. But there was really no mechanism to be able to really involve them in the actual litigation. So the best we could do is have them do opening comments, etc., or opening songs and stuff. And the tribunal was fabulous at accommodating that in a very pioneering way. But I think there ought to be court rules for the participation of children in all systemic cases. There is individual exceptions for criminal court or family law at the moment, but we have not made that important step to ensure that children can participate in systemic cases affecting children. And I hope that there are more of those to come. I'm going to leave it there because I think that I know that everybody else has a lot to dialogue about. Oh, just one other point, and that is Canada's communication. I think in our case, one of the things we benefited by was the survivors, when they told their truths of the TRC, that it educated the media so that when the government is saying things, for example, as the Prime Minister recently did in the House of Commons and during the election debate, that he is not fighting First Nations kids in court. They have the whole communication system and the megaphone of government to be able to echo chamber that into the public to make sure they feel like there's no problem here. But thanks to the survivors having told their truths, and the murdered and missing Indigenous women and girls, and the 60 Scoop survivors, and Youth in Care, now they're being fact checked. And that is really, really helpful. But being able to deal with the kind of rhetoric and spin that the feds put on their court cases is also something that I think is really important and should be considered an access to justice, because when the government won't comply with the law, the public is the antidote. So we have to be able to communicate with them effectively.
Mm-hmm. Yeah, miigwech. So I mean, not only are they not complying with Indigenous laws, but they're not even complying with their own laws. And I have to commend you on you putting together the complaint on your own with no legal background. I mean, this is something that I think lawyers struggle with for at least the first 2 or 3 years into practice. So that's really amazing. And we're all just so proud of the work that you've done. And if I can ask, this might be a little preemptive, but of course, there was just a big decision that was made on your matter, and Canada has, I guess, until Friday to decide whether they're going to appeal. Do you have any predictions, any feelings about what's going to happen next with that?
And actually, there's an appeal that was filed the day the two Michaels came back that people aren't aware of. And that was with regard to capital to ensure that there's building to provide prevention services in Jordan's Principle. So we're going to federal court anyway on that. The two matters you're speaking about were Justice Fable's decisions regarding the accessibility of First Nations children off reserve to Jordan's Principle, and compensation for Canada's ongoing discrimination against children and families for Jordan's Principle and Child and Family. Well, I was surprised to see it to Kamloops when the Prime Minister made the statement he is consulting with Indigenous leaders about whether to appeal, because none of the parties have been spoken to. Certainly we haven't got anybody. I see that the Prime Minister is heading off to the Netherlands. Unfortunately, I fully expect that there will be an appeal to the Federal Court of Appeal. But the good news is, Danielle, I really feel like this case has been spiritually guided. And that's another thing that we need to have recognition of in litigation. And I think that that's really in common with all Indigenous kinds of worldviews. The feds have thrown everything at the children. But we've had over 30 rulings, including several at the federal court and one at the Federal Court of Appeal. The kids have won all of them, except for one that was overturned on appeal. So the kids have a perfect record. I think they're going to win at the Federal Court of Appeal too. And the good news for the country is when the kids win, the country does too. The government just doesn't understand that yet. They're not at a place where they've really learned the lessons of history of residential school in a way that reforms their own behavior. So I think an appeal is coming. I'd watch for it on Friday at around 4:30, 5 o'clock. They're going to hope to ditch the media while the Prime Minister's out of town. That would, if anyone wants to bet me a cappuccino on that one, I'm up for it.
We'll send you some Starbucks cash points. Thank you, Cindy. I'd like to go to Pam, and I'd just like to make a slight correction on her bio that she's actually been practicing 23 years and not 16, and she's actually a full tenured professor. And so, Pam, I'd like to turn to you and ask you the same question about what are the most prevalent issues from your perspective on access to justice?
Well, everything that Cindy said and everything that Murray said, of course. And Murray, I was like, oh, he took my sovereignty comments. Ooh. But you know what? On the positive side of things, I've got more time to speak and I don't have to win the race of the fastest speaking person. So those were the two main things for me, was that we have to stop looking at access to justice as if it's just in the state institutions. There's also, within our own systems and laws and legal systems and recognition of our sovereignty. But so because that's been so well said, and we all agree with that, I'm going to turn to the injustice system that we have to deal with, which is about the laws, the systems, the objectives, the players in it, because those inside the justice system are in fact much bigger than most people realize. So yes, it's lawyers, judges, staff, law enforcement, correction officers, but it also is teachers, principals, social workers, and nurses. When you add cops in schools, you've now created a justice system. When you have cops in doctors' offices with social workers telling women that they have to be sterilized, you now have a gross injustice system. So you can weaponize any system into a state justice system that works against Indigenous peoples. And so we have to think about the justice system much more broadly, because think of the decisions that are made by teachers and principals that have everlasting long-term impacts on people. They're making, pseudo legal decisions around our rights, and their systems are just as much fraught with racism and misogyny and discrimination as anything that's formally recognized as a justice system. And of course, we know that Indigenous peoples are the most negatively impacted by all of these systems, and that's not by accident. Canada designed this complex weave of laws, policies, and practices for the express purpose of containing the so-called Indian problem, accessing our lands and resources, and really trying to dispense with any need to share jurisdiction, governance, decision-making, or even prosperity, for example. So, and I guess the other thing I wanted to say was around the rule of law. Nothing upsets me more than on the same day, Cindy is in the media talking about Canada failing to comply by its own laws in its own tribunal, which you would think, what? You're always talking about the rule of law. But then the second Indigenous peoples want to assert maybe a Section 35 law to protect their lands from utter destruction. Oh, rule of law must apply here. And you send in the army or the RCMP. I mean, ooh, come on. That's not the rule of law. That's the law of rulers. And that's what it's come to be. It's when state institutions pick and choose which laws they'll apply and interpret how to apply it, or if they'll ever apply it. And that goes to Supreme Court of Canada cases. You can have a monumental Supreme Court of Canada case, even with all of its associated problems in the decisions, but it takes Canada years to decide how they're going to implement it, in what ways they're going to implement it. And they make you relitigate the same issue over and over and over. I mean, I'm coming from the Mi'kmaq Nation. Hello, I thought our treaty right to trade in fish was determined by the Supreme Court of Canada decades ago, but apparently not. We're now off in a litigation process, again, to try to relitigate the same rights in their own courts with really no consequence. What is the consequence? So Cindy talked about holding state institutions to account. Okay, so what happens if they don't? Do they just get to appeal indefinitely? Do they get to just, continue on or do like Doug Ford in Ontario and say, even though it's illegal, notwithstanding, let's just do this illegal thing, and then continue to lose in court because you can't do things that you can't do? That's the whole concept of law. The fact that they don't get that, anyway, you can tell it upsets me. But this isn't just about politics. This isn't just about interpreting court cases. All of the law and this legal system and the racism and misogyny that's within it kills more Indigenous peoples in this country than any other group. And I'm not just talking about police officers who disproportionately kill Indigenous peoples. I am talking about healthcare institutions, schools, foster care scenarios. All of these institutions lead to higher rates of deaths of Indigenous peoples because of racism, which, by the way, is against the law, is allowed to continue. And we're still stuck at this debate over, I wonder if racism exists. Do you think it's systemic or do you think it's individual? How about it's all of it? The laws themselves are racist. The policies, the practices are racist. And we haven't gotten to a point where we can hold state institutions to account that doesn't rob us of all of our money and all of our time and the lifetime of children and babies, the lost lives of Indigenous women and girls. Men who are, trapped in prison now forever. Essentially, every one of their sentences acts like a life sentence on their future opportunity. I don't know how many more justice inquiries we need to do. I mean, the 1989 Royal Commission on the Donald Marshall prosecution was pretty clear that he was failed. The only reason why he was wrongfully prosecuted and all of his attempts to get out of jail failed was because he was Native. I mean, that's pretty direct. Right there. Royal Commission on Aboriginal Peoples are, Indigenous peoples face racism and systemic stereotyping in the justice system at every turn. Justice Murray Sinclair's Manitoba inquiry, Aboriginal women and children suffer tremendously, and the justice system's done little to protect them. I mean, Neil Stonechild inquiry, Saskatchewan inquiry, Ipperwash inquiry, Human Rights Watch, Truth and Reconciliation Commission, National Inquiry. My gosh, I can't even list them all fast enough to get it out, but to say Tina Fontaine, Brian Sinclair, Phoenix Sinclair, the Thunder Bay Inquiry, Vienn's Commission, Joyce Echaquan Inquiry, she would be living today if she was white. You don't need to read the rest of the report to know there is a huge problem in all of our state institutions. Ashley Smith Inquiry, BC Report on Racism in Healthcare. So you get the point. There's more than enough documented evidence. We don't need any more investigations. What we need are ways in which to hold the state to account, to end the discrimination. And I think the solution is like what Murray was talking about. You've got Indigenous laws, Indigenous legal systems, Indigenous sovereignty, and also what Cindy's talking about. You've got basic human rights here. We've got tons of human rights in Canada. Oh my goodness, just human rights everywhere at the provincial level, national level. We've got it. We've signed on to a whole bunch of international documents, declarations, treaties, conventions upholding Indigenous rights, and human rights. Both are the same thing. We should have no problem. But it's the fact that the state doesn't consider itself bound by any of these things, that when challenged, they challenge jurisdiction or applicability, but they will still wave it around and say, oh, we signed on to it. Bill C-15 is going to be a real test. They've acknowledged that UNDRIP, the United Nations Declaration on the Rights of Indigenous Peoples, is law in Canada. It's applicable in Canada. It needs to take steps to make its laws comply with UNDRIP, not the other way around. So, but how is this going to be any different than the CEDAW Convention, the Convention on the Rights of the Child, Convention Against Elimination of Racial Discrimination? And so I think, we are in a crisis. And here's why, not just for Indigenous peoples, because it ends up killing Indigenous peoples, but for Canada as a state. Because when people start losing faith in the justice system, in their governing entities, and they don't believe them and they don't have any faith that they'll hold up the basic laws or that they're even telling the truth, that can undermine an entire democracy. And you add some other elements, throw some far rights in there and some white supremacists in there who will agitate and mix up things. That doesn't put us in a good position in terms of a democracy. Look at what's happening in the United States. So this is in everybody's interest to deal with.
Yeah, and you're absolutely right. We're at a point in crisis, and it's impossible to look at these issues, especially access to justice, as an isolated issue, because it's so connected to all of our interactions that we have with law enforcement, with teachers, that somehow involve the other systems that are at play and impact and take our very lives. So I want to thank you for pointing that out, and also for another quotable, the rule of law, it's really the law of rulers. I think that's such an important piece to remember from this discussion, and really what can we do to think outside the box going forward. So I'd like to go to Brad to just add some more opening thoughts on what are some of the key issues that we would like to focus on from an Indigenous perspective.
Well, after being at the end of the three of these awesome people, can I just say I concur?
Sure.
I don't know sure what more I can add. You know, one of the things that Cindy talked about and Pam talked about was holding government to account, and that's become such a frustrating. It's not a recent frustrating event. This has been going on for a long time, and I sometimes sit back and go, why do Indigenous people always have to go to courts or tribunals on almost every single thing, whether you're talking Section 35 rights, child welfare, even things like contracts being breached, contracts that they have, agreements they have with provinces, with the federal government, and their breach. And we always seem to have to go to court. Whereas if it's some big corporation, they can issue a press release and they get a meeting with the minister right away, and their agreement gets amended, or they just say, no, we'll do this, like we won't charge you property taxes for 25 years because you're a big company with a nice building downtown or something like that. But whereas Indigenous people can't get that same kind of benefit, that kind of access. We've always got to be fighting. And when I hear what's happening with the federal government and Cindy's case, it's like, when you don't have substance, they go after procedure. They don't have anything else that they can do, so they just keep going after procedure again and again and again. And I start to sit there and I wonder, Crown has the right to seek its remedies in court, but at what point do all of these legal mechanisms that they use become a breach of the honor of the Crown? Forcing Indigenous people to go to court, is that complying with the honor of the Crown? I don't think so. And they'll say, well, it's a form of dispute resolution, but when you start to abuse that dispute resolution, you're not being honorable, and that it has to stop. It has to. We've got an agreement. We're gonna work on the agreement, with these Indigenous groups, and we're gonna do so honorably. Like, I just, after all these years and after all of the commissions and inquiries and the reports that Pam, listed off, can we get real here? And can you act honorably? And can you do what you need to do? And now we've got this law. We've got the UNDRIP Act just passed this past June. I'll tell you, in my part, I'm putting it in most of my pleadings on most of my cases, because it's read that declaration and read those principles. Canada's saying that it's going to be guided by them, or it's going to comply with them. BC and Manitoba have said basically the same thing. So then my expectation is that they'll comply with that. But unfortunately, I guess we're probably going to end up having to go to courts and tribunals again just to get that enforced. Their own laws. I'm not sure how much more I can add, because everyone else said everything else already.
Yeah, we've had a great introduction to all of the key issues, and it's hard to imagine that we'll be able to cover everything in an hour. I feel we could spend an entire day, an entire week thinking of ways to really think outside the box. And I'm always thinking of, I don't know more. That was basically the boiling point that we got to the last time we felt that we were at a crisis point, and feeling like we no longer had any choice but to take to the streets. And so, I hear, Brad, you're looking at using UNDRIP, and I'm trying to be positive. I'm trying to be optimistic that these things will work, but I still think of the limitations. And I always turn to people such as yourself of how do we push that further. I think, Murray, you had some pretty good ideas. Of course, you did the Truth and Reconciliation Commission. When we had a discussion about this before the panel, we talked about what were some of the, I guess, disappointments in terms of making that work happen, what was potentially lacking, although I can't really see how the TRC calls to action could be lacking. They were so fulsome. But were there any points in which you think that were important to build on further?
Well, I've had many people ask me to kind of do an analysis and indicate whether or not the calls to action have been complied with. And I generally say, well, it was never our expectation that they would all be complied with within this shorter period of time, since it's only been 6 years or 7 years. And in fact, I said that we probably wouldn't see reconciliation and compliance with all of the calls to action within my lifetime, but that we would see it some further down the road, because we always have to keep in mind that it took the concerted effort of the government to sway society significantly enough to be able to support the initiatives that it was engaging in. And that took several generations to do, and it's going to take that kind of effort focused upon society at large and leaders within the non-governmental community to be able to make those changes. So I don't think that's what you asked me, though. I think what you're asking me, if I'm reading the question correctly, is what could we have done better with the calls to action, and where do we think we might have been able to raise something that wasn't necessarily clearly stated in the calls. The one thing that I think that we probably could have said with greater clarity and certainty and urgently was the need, the requirement for the government of Canada and provincial governments and those other entities of governmental existence, such as municipalities or associations of municipalities, to each develop a plan of action, so that they weren't able to just sit there and say, yeah, well, we're working on it, or we're thinking about it, or here's one thing that we've done, here's a couple of things that we're going to do. Because I think the question that should always be asked is, what's your overall plan? And when do you intend to do all of those things that are necessary on your part to be able to create a process of reconciliation, a movement for reconciliation within your entity or amongst your entities or within society? And I think that could have been said with more clarity. We did recommend the establishment of a national committee for reconciliation, which was intended to be one that held the government to account, but its focus upon the government, I think, became the rationale by which the government took control of that and basically said, we'll create the committee. And it's taken them 7 years now to not create the committee. So they utilize the opportunities to delay that is afforded to them because of the lack of clarity in the wording. And I think that's probably a responsibility on our part that we could have done better. But that being said, there was a commitment to reconciliation, commitment to the process of reconciliation that had been pronounced virtually from the outset. And even during the final days of our report before it was released, that should have been the establishment of enough goodwill to make those things happen, but they didn't. And that's where we need to ensure that everybody who is involved in this process, whether it's provincial governments, corporations, federal governments, are required to state, and I think it's for the public and the media to hold this requirement up to state, what is your plan? What is your plan of action for reconciliation? And how does this particular action or these activities that you're now engaging in, how does this fit into that overall plan? Thank you.
I had a follow-up question as well, and I think Pam sort of alluded to this. Well, she spoke directly to the need for all the players in the system, such as lawyers and judges, to have that cultural sensitivity, that awareness. And I've actually seen a question in our question and answer window about cultural safety, you know, moving beyond sensitivity and awareness and competence to cultural safety and prioritizing safety of our lives. So how well do you think we've done in terms of training our lawyers, our judges, our incoming law students who are going to be entering the practice as either practitioners or advocates? You know, what is the willingness from the judiciary to implement the TRC calls to action?
The short answer, I think, is that we haven't done anything at all about that. We haven't done anything useful. Corporations say they're willing to do things. The governments say they're willing to do things, and the reality is that they're prepared to pay lip service, but they're not prepared to change the way they do business. And that's what it's going to require, is the way that everybody's doing business. The governments, provincial, federal, the corporations, whether they're involved in the petroleum or other resource industries, or just the way they function generally, banks, et cetera. The way they go about doing their business, and the way they allow their staff to continue to do things the same way without changing and without even looking at the whole question of their systemic approach to reconciliation and their systemic approach to racism and behavior, and recognizing that there's a real fundamental problem here, that we can have all the reconciliation mechanisms in place, but when we leave it up to individuals who are able to get away with treating people badly or speaking to and about people badly and negatively, we haven't obviously created an anti-racist climate well enough yet. And that's what we need to do.
Okay, miigwech. I'd like to go to Cindy and come back to this discussion about this incredible work that you've been doing for nearly 15 years now. And Canada has spent well over $10 million on legal fees alone. So do you think that the court challenges program, which I don't think enough people know about, does it need to be expanded to include systemic human rights cases per the Canadian Human Rights Act? And what other supports do public interest litigants like the Caring Society need? You sort of spoke to that in your introduction, and I'd like to hear a bit more.
Yeah, you know, when we got cut by the federal government, we had $50,000 in the bank as a Caring Society. That's all we had. I didn't even know how we'd make it like through the next quarter. And we were dealing with the largest law firm in the country. I mean, thankfully, I do a lot of public speaking, and the funds always go back to the children's cause, because that's what kept us afloat during those early days. Now, when we filed the complaint, the Assembly of First Nations and ourselves, the court challenges program existed, but it was limited to charter challenges. So really, the two ways you could get free legal help then on a case that was just giving birth and people were really wondering about was, one, a class action, and we didn't want to go that route because we really wanted to stop the discrimination from happening. That's the thing. Like, you know, when I saw the TRC calls to action, it's about stopping the discrimination. Doesn't take 20 years. It just takes a decision today to stop it. And then you get to the place of dealing with the consequences of it. And the class action, or you could file a charter challenge. And I come from a community with Delgamoot, right? I mean, I knew what that would look like. So we went to the Human Rights Commission, but we had to figure out how to get legal counsel on our own. And just frankly, there weren't a lot of Indigenous human rights cases back then, right? There weren't a lot of, when I was looking around for a First Nations, Métis, or Inuit human rights lawyer, there weren't many around. Thankfully, that's changed, right? But that was an issue back then. So it should be expanded to address systemic human rights cases. And even more than that, I'd like to see something like established here in Canada, like they have in the civil rights enforcement in the United States, where there's actually an independent arm of government that litigates on behalf of in First Nations, Métis, and Inuit peoples against the federal state. Because it is such a unique set of supports that you need to be able to do this successfully. And I just think we were so blessed to have the right people come by at the right time. But this is not an easy climb dealing with these guys, right? Mm-hmm. And just to kind of reflect a little bit on the point that Murray was picking up, one of the things we're looking at is how do you reform the government itself so it does better when it knows better? And staff training is the reflex, right? We'll train people. But what we found is actually through the great work of Amy Bombay, a shout out for her, is we actually designed a training thing and had a pre and post test for public servants. And what we found is it was all about the long arc of colonialism that I've been talking about on the call, but also bringing it up to current day. And what the post test found is that people did benefit from the historical analysis of injustices like residential schools or clearing of the plains that are in the past. But when something was on their watch, they actually doubled down on their racist attitudes. And so that has sparked the Caring Society to reach out to mind control experts and to think of colonialism as mind control. Because I think we need to kind of figure out how that they have ancestors inside of the government, bureaucrats, and this mindset's been passed down from one generation to another. And we need to figure out how do we interrupt that, because training on its own is important, but not sufficient. And it's also, I think, an issue for lawyers, social workers, and others that are engaging, like Pam is pointing to. So watch out. We've got information sheets coming out on this because we're trying to figure it out as we go. Because to me, that's the nut we need to crack. When will the government do better when it knows better? Because we have communities putting forward solutions, we have regions putting forward solutions, we have national solutions, and none of them are sticking. So we need to now, instead of drumming up more solutions, turn it back and look at the government itself.
Mm-hmm. The other thing to keep in mind, incidentally, if I can just intervene for a moment, the other thing to keep in mind is that court challenges programs that depend upon federal funding are inherently in a weak position. As soon as they get tired of hearing the argument, or as soon as they are targeted by the arguments, they defund the program. And not only Cindy's organization got defunded, but the entire court challenges program has suffered from a lack of funds recently now. So you can't do that kind of thing anymore. I think in order to have a proper court challenges program or human rights challenges program or any kind of a litigation-based program going forward, there has to be more public participation through the philanthropic community, the charitable community, the organizations in society that are energized to assist in making these kinds of things happen. I think they have to be mobilized and motivated to get involved, and that's where we didn't do enough work yet.
And I see there is a comment from a participant who pointed out the defunding of the court challenges program, and also made the suggestion of, can our gifts to faculty be directed to equality cases? And I know there's a lot of challenges for publicly funded law centers, such as a public interest law center, where they're capped at funding, or they're at risk of losing all their funding. And there is, in my opinion, an argument to be made to switching that center to private, so that you can open up those donations and call on the public to support that. So, I mean, that's definitely a possibility. And I think when people keep looking to us as Indigenous people for answers, when we've already provided all the solutions, I mean, here's the answers, support the causes that we've already started. We We need the funding to actually fight these cases in courts, and the federally funded and the provincially funded programs, they have their limits. So like our hands are tied. I want to go to a follow-up question for Dr. Cindy Blackstock, just because I know that you're potentially limited on time, and just speak really onto the UN Convention of the Rights of the Child, and that includes the right for children to participate. And you spoke about how children were limited, and I guess it was just completely unheard of in this First Nations Caring Society case for them to participate in some way. So one of the unique aspects of this human rights case was that they actually filled the tribunal room and the courtrooms, and they took a really active role in that systemic case. And I want to just hear from you, how did this play out, and what accommodations can the courts and lawyers make to ensure that children participate in systemic cases?
Thank you, Danielle. And I need to just say that these children have taught me so much about advocacy. I mean, they reminded me that you do a social movement of this nature, not on the basis of anger and tears, because that fuels the injustice, but on the basis of love and light. And that really is a teaching that's been handed down through many of our cultures. These kids, because they hadn't been subjected to the propaganda by the government about First Nations, Métis and Inuit peoples, they saw the unfairness right away. And they started to come on their own to the courtroom. We invited the Canadian public to come to the court, but it was empty, including amongst groups that you would think would be there, like human rights lawyers or social workers. Well, we weren't there at the beginning. Children started to come because they could see the unfairness and they wanted to learn. And they would not only learn and come to the hearings, they would bring their families with them. They would bring their younger brothers and sisters. So by 2012, we had to book them in shifts. And you can see this live on Ellen Niesel-Bomsawin's great documentary, We Can't Make the Same Mistake Twice, about the whole court case. Now, the children, as they became more aware, wanted to do something about it. And that's the other wonderful thing about kids. So they were writing letters to elected officials because they knew these elected officials could make a choice to stop fighting the kids and treat them fairly. But some of them wanted to testify. And when it came time for the opening comments, there was no way to be able to get them to testify and without being subject to pretty aggressive cross-examination. You need to remember, around the same time period, Canada was asking me questions on the stand, like, do you believe in God and were you in child welfare care? So we couldn't subject children to that kind of cross-examination without rules. The other thing we needed is just a space for them to go and to make the lawyers accessible. Our wonderful pro bono lawyers, David Taylor, Sarah Clark, and others, always made themselves available to meet with the kids and explain and answer their questions. And you need to be willing to do that because they ask really, really good questions. And there ought to be an opportunity too for children to submit in writing or through oral history or with supports of elders. Kind of like the accommodations we've made in the federal court rules around elders testifying, there ought to be similar types of accommodations for children. And it shouldn't just be like, in this case, it's about First Nations children, but we should invite all children to have that same right to participate. Because what all children understood is this was about the type of society they wanted to grow up in. And they all knew that they did not want to leave a generation of kids behind. That was really clear. And they all wanted to be heard at that hearing. We did a video of the children where without any coaching, they just made their statements. But Canada refused to have that shown at the tribunal. They said, quote, it wasn't appropriate. So we posted it on YouTube and circulated it around. And that's how we dealt with that. But I think that there's lots of wonderful teachings from this case, and a shout out to the tribunal. And not only the tribunal, the kids came to the federal court and federal court of appeal, and they were welcome there too. And so that it's been a real landmark case. And I think we just need to put the infrastructure behind that, so that other children wanting to participate at that level of court are able to do so in a way that really supports their enjoyment of the right to participate in litigation.
Mm-hmm. It was so beautiful to witness that. And I think it's just so amazing that the tribunal case was also the first time that APTN was able to come into the courtroom and broadcast that, like, to be an Indigenous person and see an Indigenous representative media President, I think is just such a historical moment. I wanted to go to Pam and talk about, you have more of a unique position. You've been an advocate for 23 years now. And I wanted to know whether you find if it's easier or are there some challenges or some limitations from your position in putting pressure on the government to deal with some of these issues that we're talking about, like accessing counsel, accessing legal information. What have you noticed in terms of meaningful change in recent years?
Wow, such a good question. So full disclosure, I did 10 years hard time in the feds. I was at Justice Canada and Indian Affairs, like literally if you had to pick the two worst ones. So I have a great deal of insight as what it's like to be a lawyer at Justice Canada, what the attitudes are. Obviously, I can't talk about the files, but the same kinds of attitudes, and we're gonna get those Native people replicated in Indian Affairs. Yes, there's always nice people that work at institutions, but unfortunately, sometimes some of the bureaucrats take this stuff personally. I don't know how many times I've heard over my dead body, that will never happen. You guys don't deserve this. Stop complaining. I'm going to make it a point to do X. I'm going to make it a point to do Y, or just never answer you or never respond to your requests or keep you going. They have this thing called, it's like, you can't say yes, but don't say no and risk a protest. So it's managing the non-answer for as long as you can. I mean, that's the government in a nutshell. Try to hold off this litigation over here, not because they don't know it's not an issue, not because they're only being told by Cindy, oh, racism and child welfare. Yeah. Oh, that's an issue. Wow. It's how long can we hold all of this stuff off? It's about delay, 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 delay. And think about that across the board, what happens. So if you delay long enough for First Nations women being kicked out of their communities under the Indian Act, well, a large number of them will be deceased by the time they are reinstated, and then you don't have to worry about the so-called financial obligations. Think about it in terms of land claims. The longer you don't deal with it and don't delay it, you can strip it of every single bit of resource that's there. And so then when it comes to Indigenous peoples, it's already a done deal. The best you're going to hope for is money. And it's like that across the board. So I thought, in fairness, I worked outside prior to going inside. I worked inside. And of course, everybody who goes in, I'm pretty sure, goes in thinking, I'm going to change. I'm going to, do what's right. I'm going to whatever. But it's actually not that easy, or there would be like a lot of changes right now. So then I decided, on the outside, I think I would be far more effective. I think now I'm far more effective on the outside because of my time on the inside and outside. I know with a degree of certainty exactly how they think, exactly what they're going to plan, exactly the Justice Canada weasel words, things to look out for. So even when they make a so-called commitment to a First Nation in a negotiation, if they use a certain phraseology, it's like, oh, so they're actually not going to do that. This is what they say every time they do X, Y, and Z. So, even without breaching any confidences or anything like that, it's the skills, the knowledge, the strategies, how they do things that I find it so much more effective, especially in terms of analyzing legislation and regulations, having taken all that training for legislative drafting and interpretation and what they do and what they don't do. Then I know it's not true when they say they co-draft legislation with First Nations. No, they don't. They don't co-draft legislation with anybody, but they can sell these things as politically, happy, politically attractive words without dealing with all of the substantive issues. And here's how I come down on all of it, inside, outside, both, whatever. Law is as much politics as it is the words on the paper. The government, whether it be federal, provincial, municipal, corporations, agencies, you name it, they all have, for the most part, the power and the resources, because there are resources, to make decisions to do the right thing. When I heard Justice Canada arguing that they had to appeal this decision in Cindy's case because, well, you know, some of these compensation amounts would be too low. I was like, so what's stopping you from tripling it? And the answer is nothing. They make these bizarre claims that even a child listening to that would be like, oh, okay, so why don't they just give more? And it's like that across the board. We don't have to litigate. I would say the vast majority of these things. We don't have to be in tribunals for most of these things. Canada knows. They have some pretty smart people in there. They know when they're on the wrong side. This is about delay, minimize, you know, for if they're thinking about election terms, they're thinking about how much money has to outgo, and they're ultimately thinking about, don't forget, the power. So it's not always just resources. If you're talking about decisions and changes, substantive changes, that would mean shared decision-making in some areas or exclusive decision-making in some areas. That's enough to set them, you know, alarm bells off for them. So sometimes we think of it as just a matter of resources. This is also a matter of power and joint governance and making way. And that's why when people talk about, oh, you know, should we just sign up for cultural awareness training? Oh, my head wants to explode. No. And that's not to insult culture, because yes, our culture is important and people should understand the significance of it. But I have yet to see a police agency, a corrections agency, a hospital, even a university take cultural awareness training and it have any impact on what it is they're doing at all. Now, if they had to live up to, if they had cultural safety training, direct anti-racism training, and then after that training, have a accountability framework where you measure and account for who is abiding by human rights and who isn't, and what are the consequences for that, measured over time and measure the impacts, yes, that's fantastic. But so long as we continue to look at reconciliation as, here's my list of activities I did. I had an elder do an opening. I did cultural awareness safety training. I did this celebration. I had a guest speaker. And you're not measuring the impact on the actual Indigenous peoples themselves. How many people are out of prison now? How many kids are not in foster care? How many women are living healthy, safe lives away from violence? If we're not measuring the things that matter, the things that directly relate to these human rights, we got it all wrong. And that's where cultural awareness and Aboriginal History 101 falls down. We historicize it, or we make the problem our culture. If only you knew more about our culture's never been the problem. It's your racism, your misogyny, your objective to take our lands and resources and control and dominate over this territory. That's the problem. It's never been our culture. Our culture is beautiful. And so because we have it all backwards, I'm not at all surprised that we're making these shifts inside or outside the government.
Yeah, it's very challenging. We have these discussions at the law school level too, you know, when we're introducing cultural sensitivity. There's that course that's offered through the University of Alberta that that guy from Schitt's Creek, David Levy, made really popular, and a lot of students and the Law Society are now offering this as a mandatory course for articling students. But at the school level, none of this is mandatory. We have like a week intro into, this is our culture, we're going to go set up a teepee. And I'm sorry to say, it's just not enough, because there, like you exactly just pointed out, there's no way to measure whether people are meaningfully engaging with that material, and really challenging those mentalities that they've basically gone through elementary school, high school, and their university education, coming to an understanding of. So I feel you. I was just like nodding my head in agreement, Pam. And Brad, I'm so sorry. I'm going to have to, go to you and say, you spent a year as the president, and I'm sure all of these issues came up. There was a question from the audience. What was your experience in trying to engage the legal profession with these issues on the CBA executive? And I just also want to acknowledge that you are also speaking from the perspective of a member of a small group of Indigenous lawyers who really put their feet to the ground to do the work over 20 years ago. And you're the people that we look up to, and we want to know, like, who did you look up to, and who do you, I guess, turn to in trying to tackle these huge issues? 5 minutes or less. Go.
Oh, okay. Well, now you made me feel really old. But if you were an Indigenous law student or lawyer back in the 80s, 90s, or 2000, you were looking at one person, and he's in the middle of my gallery view there. Murray was the guy that we looked up to, and I'm pretty positive everyone who was in Manitoba in the, going to law school or practicing, Murray was our icon. He was our the person we looked up to. I mean, and rightfully so, because he's awesome. But there were other people too we looked up to. I mean, I think of Harry Laforme. He just spoke at the Indigenous Bar Association conference just a Saturday morning about some of his experiences. The late Carol Kokorin, of course, was someone that we would look up to. Jean Taillet, Dave Nawagabo, Mary Ellen Turpel-Lafond, Roberta Jameson, and Willie Littlechild. And there are so many more, but these were our icons. These were the people my generation looked up to. In terms of the CBA, I did 2 rounds on the CBA National Board, and on my second round, the CBA wanted to respond to the TRC's calls to action and made it a priority. And I remember in 2019 we had a board meeting and we passed the work plan. I guess board minutes are supposed to be confidential, but I think my exact words at the board meeting were, "I want this passed today." And the work plan got passed, and the organization made the commitment and began implementing. I think earlier on, it was mentioned, we had our most successful CPD program called The Path we developed with Envision, based out of Ottawa. We've had 3,200 lawyers, over 3,200 lawyers take the course in the last 18 months. We handed out, I think it was 300 or is it 400 free initial, you could access the course for free. Those were taken up in, I think, less than 13 days. We thought it would take a few months, but it was overwhelming. We sponsored Myrna McCallum's Trauma Informed Lawyering, which has been her podcast series has been a huge success. My understanding is at least some of her sessions are mandatory viewing at least one California law school. The Path, I understand, I think all first-year law students have to take it at University of Alberta. I did my own podcast on TRC. In fact, Cindy and Pam were my very last guests on my podcast series. And I was able to speak to the American Bar Association, their big council meeting in August, because they passed a resolution supporting Secretary of Interior Deb Haaland's. She's trying to push for a Truth and Healing Commission in the United States to deal with their residential school. So that was, I was really honored to have been able to ask to speak to that resolution. And, and other things that I tried to focus on was, obviously, we talked about systemic racism, the finding of the children in the spring and throughout the summer. That was, that was tough for a lot of people, but the association issued its press releases with statements from myself, and we continued to do so because that was my feeling, was that the legal system, the legal profession really needs to embrace these things and really needs to change the way it thinks about Indigenous legal issues, and the legal profession's relationship with Indigenous people really needs to evolve. And I think the association wants to do that and is doing that through a lot of the initiatives that it's doing.
You have done incredible work, Brad, and I know we were discussing before we went live that we think they should just give you another round at being president because you had to deal with the pandemic.
Okay,
no, we thought they should give him another round.
I mean, we'd be honored to have you again. And I want to say on behalf of all of us in the profession and as advocates that we're just so proud of the work that you've done in the CBA. I think we have some time to go to some questions from the participants. And there's one that stood out for me. It really speaks to, I think, the indigenization or the decolonization of law, and whether there's a need for legislation in order to recognize Indigenous legal systems. If anyone wants to take a stab at that question first, maybe Murray. He's probably taking some notes.
Well, no, the answer is no. If everything proceeded logically as it should, the answer is no. Why would you, if you think about it, in many ways, we have become so dependent upon getting the federal government to solve the problems that it's created that we automatically turn to or think that we need the federal government to sanction this process. And that's the first mistake we make. And then this third mistake, the second and third mistakes are often we get involved in helping them, and then we get involved in approving what they've done. So no, the answer in my view is that it's about time for, first of all, for lawyers to begin to recognize that this is an important issue, and for the scholars in the legal community to assist in doing the research and the writing and the thinking and communicating the philosophies and doing the necessary foundation work that's needed in order for us to be able to articulate what these principles are all about and what this issue presents to us, and the necessity for it, all of that. Right now, there's very little scholarly work that's been done, and the scholarly work that has been done to this point in time has been relatively good, but I think it needs to be built upon, and I think we need to look at the very question is, and I always start off with this very simple proposition: if the white man had never come here, what would we be doing? And I think that's the concept we need to think about, because we would be doing something, we'd be functioning, and we'd have adapted to world evolution, the way the world changes. I remember a famous incident that was in the newspaper by the Minister of Defense, Richardson, I forget his first name, was Jim Richardson, who said, what have the Indians ever done? They never invented the wheel. Well, that assumes that the wheel was a good thing. It isn't necessarily the necessity, unless you invent roads, unless you have roads upon which wheels can travel. And so the reality is, though, that once needed, we would have done what the rest of the world does, which is we borrow ideas from other nations, from other societies, from other cultures, and we adapt them to our particular environment. And every society does that. Every culture has done that. Canada didn't create anything either. When we borrowed everything that we've claimed credit for from other nations. So the reality is that I think it's about time for us to begin to articulate these principles and these points, not only to courts, but to ourselves, so that we understand them and we believe them and we know how to talk about them, and that we can show other lawyers just how important this is, not only just in the field of Indigenous law, but it's also important in the field of contracts. It's important in the field of insurance law. It's important in the field of criminal law and criminal behavior and human rights law. But it's important as well to the whole question of relationship between Indigenous and non-Indigenous societies. And so that's the question I think that we need to begin to think about, and that is, what would we be doing if the white man had never come here? And if you think about it that way, the answers start to present themselves.
I love that. We have a few more minutes left, and I think I'd like to just close off before handing it back to Natasha for some closing remarks. if you could each maybe just take a couple of minutes to think about what are some things that law firms, either small or independent or medium, large, what should their priorities be in terms of all of these issues that we've just spoken to? Because I think a lot of the time people are leaving these types of engagements wondering, well, what can I do? Right? What next? And unfortunately, the question is always sort of put back to us, even though there are so many answers out there. But from your own perspectives, in a couple of minutes, what do you think is the main takeaway from this? Let's start with Dr. Cindy Blackstock, please.
Everyone, this teddy bear is Spirit Bear, the only barrister with the Indigenous Bar Association. So he and I have been through a lot together because he comes to all the hearings, and he is proud. Underneath his orange shirt, he's wearing his TRC button that Murray gave him. So that's why he's always with me. People ask him if he's my comfort bear, and I guess he is, but he really belongs to the kids. What I'd say about how you can make a difference, I'm just going to be really practical. Get a hold of your member of parliament right now and the prime minister and tell them not to drop their appeal on capital and not appeal this order on Friday. It's time for the government to put down their sword and stop fighting these kids. And also today, they're fighting the residential school survivors from St. Anne's Residential School, Danielle, who are victimized by an electric chair in that school. Like this is going, it's kind of like that mindset others are talking about. It's fighting for fighting's sake instead of doing what's right for the country. I've often wondered, as I've sat back and wondered why Canada is doing this, I thought, what is the vision of the country that you're fighting for? Because I know the one that we're fighting for is one where First Nations children are respected, where they're honored, and where their families are given a good chance to raise them in ways that make their ancestors proud. That's what we're fighting for. But I don't know what the federal government is fighting for. And the world that they seem to be fighting for is one that I don't want to be a part of. It's not a country I would feel proud of. And I think the kids knew that instinctively. I'm going to put in the chat, we have 7 free ways to make a difference in under 2 minutes. And I'd really recommend you do that. But I would love to see out of a convening of experts like we have on this call, someone to begin the hard work and important work of writing those guidelines around systemic cases and making sure that there is capacity for public interest groups like ours to bring those cases and to have groups like the IBA actually list out what are those likely barriers you're going to get. Everything from the denials from the federal government, the procedural things that they'll use against you, and how could you kind of navigate your way through this so that you're not literally doing it on a hope and a prayer and a bear like we have.
Miigwech. Let's go to Brad. If you can just take a moment. We have about 3 minutes remaining.
Don't just talk the talk, walk the walk. Be prepared to change. Like don't go, oh, we're going to go or do our cultural competency training and we're going to watch a bunch of CPD sessions and all this kind of stuff. And then everything remains the same. Be ready and willing to change. I think about one of the things, the sort of the EDI initiatives, equality, diversity, inclusivity. Don't just say, oh yeah, we're committed to that. Well, you got to move beyond that. You need to make sure that your firm is actually welcoming and opening, and don't sort of just dump on, those staff members or those lawyers and go, well, you tell us what you need to do. This needs to come from the leadership of law firms. Lead by example, lead from the front, not from the back, and be prepared to change, and maybe even look at how are you pleading cases? How are you approaching things? If you're really committed to reconciliation.
Miigwech. Pam.
Okay, really quick. What Cindy said. So, every single lawyer in this country should be making a social media post saying, stop fighting St. Anne's residential school survivors in court, stop fighting First Nation kids in court, stop fighting First Nations women under the Indian Act in court. Cabinet could make that decision the day they're back. So this isn't a multi-generational issue. They could do that. Lawyers, take a stand. Just like we're telling doctors take a stand, nurses take a stand, police officers take a stand. You got to actually do that. And, some practical stuff around law firms around here. They could be developing better relationships with First Nations communities, not just based on solicitor client, but have Indigenous experts in residence. Think about the lawyers that upset you, worry you, make you stressed out the most, give you the most amount of anxiety. Those are the Indigenous lawyers you want in your law firms giving you advice, not the ones who are saying everything is great. So those three things, boom, 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 and we've got a good start.
Thank you so much, Pam.
Can I have 2 words?
You got 2 words.
2 words. Become anti-racist.
Yes, that's all you guys need to know. Thank you so much. We're going to pass it back off to Natasha. We've accomplished and gone through so much. Thank you, everyone, for your great questions, and miigwech to all of our amazing panelists. This has just been a powerhouse lineup of people and discussions, and I feel so, my heart is so full. I want to thank each of you for sharing all of your wisdom.